You want to?
Right.
Yeah. Thank you.
Hi, everyone. Thanks for joining us today. I'm James Boyle. I'm a partner at Vinters, and I lead the privacy and data protection team here. What we're going to run through in the next kind of 40 minutes or so are all of the kind of topics that I think tech-based charities kind of need to know. In putting the presentation together, I focused more on covering lots of different topics at a relatively high level rather than going into detail on anything in particular. But if anything comes up that you'd like more detail on, or if there's a particular question that's relevant for you as we go through, then please just drop a chat request into Zoom and I'll pick up on that. So let's get into it. As with the content, what we're broadly going to run through today is set out in the kind of 8 points around what you need to know. So we'll start by looking at what personal data is. And the reason why we start there is because when we talk about the data protection legislation, that will cover personal data. So the flip side of that is if what you're handling doesn't meet the definition of personal data, then the data protection legislation doesn't apply to that. Second point, which comes up quite a lot for tech-based charities, is that you don't need consent for everything you do with personal data. In part 2 of the session, we'll look at some specific scenarios where you do need consent. But one of the kind of common myths that we still see coming up in privacy and data protection is kind of thought that you need consent for everything you do with personal data. Third thing, which is probably worth mentioning right at the start, is that even if the personal data that you're collecting, whether it's for research or commercial purposes, if that's in the public domain, then it's still caught by the rules we're discussing today. There's nothing in particular that exempts personal data in the public domain from being subject to data protection rules. We'll also look at when you're a data controller and when you're a data processor. These two statuses at points 4 and 5 are super important because which one of these you occupy broadly determines what you have to do under the legislation. So you need to do very different things when it comes to, for example, data breaches or responding to things like subject access requests or requests for the data to be deleted if you're a controller compared to if you're a processor. We'll also run through some guidance on how you can create analytics from the data you hold, whether or not you're a controller or a processor. We'll then also look at the new guidance on cookies, and we'll end by looking at when your communications qualify as direct marketing, which are tightly regulated by a second piece of legislation called the PECRs that some of you are probably already familiar with. So in part 1, we'll cover the key concepts, and in particular, we'll run through what's personal data, when are you likely to be a data controller, when are you likely to be a data processor, and confirming that you don't need consent for everything you do with personal data. So when we talk about personal data, we mean information that relates to a living individual, which enables you to identify them. It's quite a broad definition, and that includes clearly somebody's name or an ID number that you give to them, location data about them, or an online identifier such as an IP address, as well as anything else you store that enables you to identify somebody, even if on its own, that data point wouldn't be personal data. And in terms of what I mean by that, if all you were holding, for example, was the first 3 digits of a postcode and nothing else about somebody, that wouldn't be personal data. But as soon as you combine that first half of the postcode with your more general record about that person, such as their name and their email address, then that whole record is their personal data. There's also a kind of second type of personal data called special category data. These are things like health data, trade union membership, things like political beliefs as well. I'm not generally going to cover those in detail today unless there are any kind of specific questions. We will touch on it a little bit later on, but as a rule of thumb, if the data you're handling qualifies as special category data, then the rules that apply to that are a little bit stricter. So, based on the previous definition, which is that personal data is any information that enables you to identify a single living individual. We'll run through these kind of 6 options on the slides and look at whether they are personal data or not. When we usually run this face-to-face, it's run as a quiz, but because it's a Zoom presentation, I've put the answers up on the slide straight away. So if we look at the first one, from population health trends, on the assumption that there's simply no way you could identify a single living individual from, say, general statistics about the average age, or general statistics about the demographic breakdown of a particular area, that wouldn't be personal data, because the data is too aggregated and it's not granular enough to enable you to identify somebody. It's the same point really with an aggregated number of donations. So if you're a tech-based charity working out what's the average donation you received over the last year, that's then pulled into a kind of standalone document that talks about the figures, but with no kind of reference to who's actually made those donations or where they've come from, then that wouldn't be personal data either. A slightly more complex example at point 3 is a J. Smith of 16th Street, Washington, but they're deceased. In the UK and across the EU, personal data applies to living individuals, not deceased individuals. So in the UK and EU, that third point wouldn't be personal data. But it's worth keeping in mind that in some jurisdictions, particularly in APAC, their local legislation can include deceased people for a period of time within the definition of personal data. So let's move on to the next one, which is supporter contact details. And by contact details, we can assume that I mean name and email address. In those circumstances, you clearly can identify a single living individual. So it would be personal data. Exactly the same point for my name and Taylor Vinters, the firm where I work. So that would be personal data about me. But then I've included the final example to really illustrate that this question isn't always clear cut and that sometimes it can depend. So if you hold partial genomic data about somebody, that may or may not be personal data, depending on whether you can identify a single living individual from that genomic data. It's likely that the more detailed genomic data you hold, then the more likely it is it's personal data and that you can identify somebody.
Can you give an example? Can you give an example?
Yeah, of course. Yeah. So if for example, you held an entire genome sequence of somebody that was completely unique to them, and there's no way that like anybody else could have exactly the same thing, that's much more likely to qualify as personal data. But if all you held instead was a few generic genetic markers that might reveal a kind of predisposition to certain cancers, that's less likely to be personal data. But I think that the key point to take away here really is that often it's fairly straightforward to work out whether or not something is personal data. But the real test is like, how likely is it that you can identify a single living individual from the data you hold? And for things like genomic data and other data sets, it's not always as clear cut as that. Okay. If we've, for those of you listening to this, if you've established that you are holding personal data in at least some way in your organization, and almost certainly you are, when you are handling personal data, you'll usually do that in one of 2 capacities. You'll either be what's called a data controller, or you'll be a data processor. And on the next slide, I set out some indicators to help work out whether you're more likely to be a controller over the data you're handling, or if you're more likely to be a processor. And so if you're handling personal data and you decided to collect the data, or you decide what the end outcome is, or you decide what data is being collected, if the data subjects are your employees, or you exercise some kind of expertise or professional judgment over it, you have a direct relationship with the individuals and nobody else really tells you how to use the personal data, then you're much more likely to be a controller over that data that you're handling for that purpose than a processor. What I'll also say is it's quite possible that as you kind of read through that list of 7 points and apply that to your organization, you might think, well, I do some of those, but not all of them. And that's absolutely fine, because these are a list of indicative factors. The real kind of litmus test around when you're a controller is ultimately, are you deciding why and how the data is being used? If the answer to that question is yes, and you're very likely to be a controller. These list of 7 on the slide are actually taken from the Information Commissioner's Office, the regulator, as kind of helpful indicators for you to work through and determine if you're likely to be a controller or a processor. In a couple of slides' time, I've given it a breakdown of like typically the kind of things that tech-based charities would be controllers of, and the kind of things typically they'd be a processor of. So on to the next slide, we have a very similar set of indicators, but for working out if you're more likely to be a data processor. And so if when you think about the personal data you're handling, and you think actually somebody else is telling us how to handle this data, we were given the data by one of our commercial customers or a third party, or we were told what to collect. If you didn't decide to collect the data, you didn't decide what it should be used for or how long to keep it for, and you're not interested really in the end result of the data handling, then you're much more likely to be a processor. And so if we flip on to the next slide, generally, based on our experience of helping tech-based charities, we see that they're typically a controller over employee and applicant data, as well as supplier data, marketing lists and people that attend their events, as well as customer service queries. Customer service queries can be a little bit more complex, because sometimes you may have that customer service query come in about a set of data that you're processing for your customer. So that's why I've put customer service queries in both. And our tech-based charities will typically be a processor over all of the data that their customers are putting through their platform.
Can I ask you an example?
Yeah.
So in fact, we just had a presentation this morning. Presumably you're quite familiar with digital passport. If I say digital passport, yeah. So one of our digital passport, instead of the mobile phone, is actually a wallet in the cloud. And then the wallet is encrypted with the vein scan of the user.
Okay.
So do you think that will be a data controller or something?
So I think the application that creates a digital passport will probably be a controller.
All right.
On the cloud system that the passport is stored on, which might be somebody like Amazon Web Services or Microsoft would be a data processor in those circumstances.
All right.
The other way that's sometimes helpful to get to the bottom of this is to ask the question, if I was an individual that had this digital passport and I wanted to delete my data, who would I ask to do that for me? And usually it would be the creator of the app, I would ask.
Yes, that's right.
So in those circumstances, as a rule of thumb, the person that you would ask to delete the data is very likely to be the data controller.
Okay.
It was a good question, though. And so you might quite rightly ask me, I get the distinction between data controllers and processors, because hopefully I've explained that clearly enough. But why does it actually matter practically? And that's because the obligations that apply to controllers and processors under data protection law are really quite different. So for data controllers, they have to clearly communicate to people how their data is being used. And that includes all of the really awkward stuff that you might rather not tell them. So for example, if you're researching potential supporters or customers online before reaching out to them, you're kind of working out actually, are they wealthy enough for us to bother reaching out to them? That should really be communicated to the public at large, usually via a notice on your website. Controllers also have to identify what's called a lawful basis to justify their use of data. But that one's particularly important, and there's a whole slide dedicated to that we'll come on to a bit later on. Data controllers are also primarily responsible for handling things like subject access requests, dealing with erasure requests on the lines of what we've just been talking about. And controllers should also be completing data protection impact assessments for uses of data that are considered high risk. The reason why there's an asterisk on the DPIA point is because there's quite detailed guidance in the UK on the ICO's website on when a data protection impact assessment is required. So I've simplified that quite a bit. There's also some different jurisdictional variants on when a DPIA is required across EU and globally. Some jurisdictions won't recognise DPIAs, or they'll have something slightly different that you need to do. So contrasting this to what do we do if there's more than one entity involved? One thing that's particularly relevant for tech-based charities working with the university is that they may actually qualify as being joint data controllers with the university. And I'll explain what I mean by that in a bit more detail. So if more than one entity is involved, it's possible that a joint controller relationship can arise. And if you're an independent researcher or working in collaboration with the university, where you're both deciding kind of what data are we collecting here and what's the purpose of the project, that's the kind of relationships that can give rise to the joint controller model. If you think that's relevant, then I'd suggest speaking to the university's tech transfer office or take legal advice, because the joint controller arrangements can get quite complex quite quickly. To give you a kind of brief overview, it's important that you both controllers, so both potentially your spin-out company and the university, would work together in advance to decide, well, how are you going to work together if somebody writes in to say, I want a copy of my data, or somebody writes in to say, I want you to erase all of my data. And it's worth kind of thrashing that out with the other controller at the outset and getting it right from the start. Moving on to kind of why this distinction between controllers and processes matters. Well, if we look at processes, then processes are usually viewed as service providers for data controllers. And processes as well must know where the data is going, like who their sub-processes are. So if you're listening to this and you're using somebody like a third-party support ticketing system, a hosting provider like Amazon or AWS or Azure, or some kind of integration partner, it's really, really important that you have a grasp on what data are we sending them, where are they based, and what are they using it for. And that applies equally to controllers. So more and more recently, particularly in the last kind of 12 to 18 months or so, it's becoming really important that controllers have like complete visibility right the way across their supply chain. And in order for them to do that, their processes have to have that knowledge as well. It's also important that when processes are working with controllers, that there are contracts that meet the minimum UK GDPR standards that are in place. Again, this is also an obligation on controllers.
Sorry, I noticed you place an emphasis on recently. Has there been any new law? Okay.
Great question. In the summer of last year, there was a case called Schrems 2, which led to the invalidation of what was the Privacy Shield, which enabled data transfers to go from the EU to the United States. One of the things that came out of that case was a really increased requirement on parties to really know, where is your data going? Are the processes handling that data actually keeping it adequately secure? And particularly from things like public authorities in the local territories having backdoor access to data. This obligation to have complete visibility over where your data is going has been in place for years. It's just happening that over the last kind of 12 to 18 months, we've started to see the legal cases coming out that kind of back that up. And I've certainly seen that filter through into the commercial deals that I've been doing, where now parties are a bit more nervous about making sure they have complete visibility and control.
So these people, the user or the data owner, actually sue personal data being transferred from EU to United States. Is that the case?
Yeah.
Okay. Just while you're on that topic, I keep hearing people about data not leaving the sovereign soil. Is it
Yeah.
common? It's also quite common, is it? Yeah.
Great question. So generally, as far as the UK and the EU data protection legislation is concerned, data can flow around the world, provided it's adequately protected. I think some of the laws in other jurisdictions are a bit more reluctant about enabling global data flows, but the starting point under the GDPR, the UK GDPR and the UK Data Protection Act is that data can flow globally. But when we look at that obligation to make sure that the data is kind of being adequately protected when it is flying around the world, sometimes it can be very difficult to know that the data is absolutely being properly protected around the world. So that has resulted in, I think, some parties quite reasonably saying, well, even if the law says data can flow globally if it's properly protected, we would feel more comfortable with it being stored in our local territory. So certainly from my experience of this, that requirement for like data sovereignty or like data not leaving a particular jurisdiction is more a way to give customers comfort that the data is being adequately precisely, rather than something the law says you can't do. But you might also question whether data transfers to the US, which was a subject of the Schrems 2 case, can be adequately protected to the EU standard. There are some reports coming from regulators in the EU suggesting that actually they're not happy with data transfers at all going to the US, so they would rather it was stored in country or in the EU at least.
In fact, I have a very interesting question for you. We actually encounter this problem because we are working with an Indian partner, and then in India, they say that the data cannot go outside. However, when we are filling in all these due diligence, and then the Indian partner was asking us, when we put the data in the cloud, how do we know where it is physically? So how do we say that we are okay or not? So what will be your advice? I mean, when we go to Amazon Cloud, it could be any machine, isn't it? It could be any location.
So that depends on which version of the Amazon Cloud you're using. I certainly have clients who, they might have paid a little bit more to do this, but they have selected like an Amazon data center in the UK or in the EU, for example. So it's definitely possible that even if you're working with a data center like Amazon or Microsoft, you have the data stored in one of their data centers in a particular geographical location. That's something that I would be inclined to ask your account manager at Amazon, or it's probably the kind of thing that you can control in the like admin panel. On that. But yeah, definitely worth looking into that. That is the kind of information that you should be able to get access to quite quickly, because this is quite a hot topic at the moment, and the bigger providers certainly have already thought about that. Perfect. So one of the other key obligations I wanted to run through as we're kind of establishing the key concepts is that when you're a data controller, it's really important that you publicly communicate how you use data about the people whose data you're collecting. You can do this via notices on your data collection forms and usually a privacy policy on your website. Also, if it's appropriate, think about communicating basic privacy information when your supporters or customers call you. My view is that poor or bad privacy notices look like legal contracts. Good privacy notices are fairly short, they're written in plain English. Also, consider using things like videos, icons, QR codes, and infographics to communicate privacy information. These shouldn't be overly legal, overly engineered documents. This is meant to be a communication to your customers about how you use their data that they will understand. And it's really important when you're kind of crafting your privacy notice or your communication on your website that you bear that in mind.
I don't understand. How do you use the QR code? I mean, like even icon.
So as an example, we've just helped a client that has some kind of recording applied to vehicles on the road in the UK. And on the side of a vehicle, it is impossible to communicate all the privacy information you might want to on the side of a vehicle. There's just not enough space and people wouldn't read it. So what we've done is we've had on the side of the vehicle like a notice that there's recording equipment being used, who the data controller is, and saying if the individuals want to find out more information about that, they can scan the QR code.
Ah, okay.
So it's a way of what's called layering privacy information, and it reflects that in some scenarios you can't always hit people with your full privacy notice explaining what's going on, and actually sometimes it's better not to, because people won't engage with it as fully as if you provided it to them in stages.
Okay.
So what I've included on the next slide is our own interpretation of how to do a privacy policy that's a bit more engaging. So this is taken straight from our website. And what we've done is, rather than have it as a static piece of text, you're invited to kind of click on like in what capacity you're working with us, and what capacity you're kind of looking for more information about how your data is used. I'm not in any way saying this is the only way, or like this is the best way of doing this. I'm just including this as an example of how you can do something a little bit different with how you communicate privacy information. And ultimately, the aim here is to get this information across to your customers, clients, supporters, job applicants in a way that they understand and is clear. I would really, really encourage you to avoid making these overly engineered from a legal perspective. Of course, there is certain mandatory information you have to provide, so it's a bit of a balancing act, but I certainly think this can be done in a really neat way that looks kind of engaging to your customers as well. So as we're continuing with the key concepts, I mentioned earlier that one of the really important topics when you're a controller is to establish that you have a lawful basis for how you're using data. And all of the available lawful bases are set out on the next slide. And so when it comes to the, thank you, Jane, I'm glad I've got a supporter in terms of how we communicate these documents. And so when we're talking about holding personal data as a controller, we can only do that in compliance with the legislation if we can identify a lawful basis or a reason for handling that data. And I'm going to focus on the green boxes down the left-hand side. And the key point here is we need to choose which of these options in the green boxes best reflect why we're using personal data. And in some circumstances, that may well be because the individual has consented. In other circumstances, so where somebody's bought something from us, the reason that might best describe why we handle things like the name and address to process their order would be because it's necessary to perform a contract. But the third box comes up a lot, which is where it's in our legitimate interest. And this one is really recognizing that in some cases, we might not have consent from the individual. We might not have a contract in place with them, but we may still be able to show that our intended use of their data is still fair and reasonable, and that we have a legitimate interest in using their data in that way. Now, because legitimate interests, when I explain that to my clients, a lot of them often go, well, this is brilliant, so I'm just going to say that everything is in my legitimate interest and I can do what I want. The messaging from the regulator here is, well, not so fast. You can only rely on legitimate interest as your lawful basis if you can show that your use of their data doesn't unfairly or unnecessarily impact on their privacy rights. The way that you should be doing that is in what's called a legitimate interest assessment, particularly if you're a UK-based data controller. The good news is, this all sounds very complicated, but there's a free template on the ICO's website that has a legitimate interest assessment there, and you can just walk through that one. If you have any questions on how to complete those at all, then please just let me know. I can hang around after and we can talk about that. So what I've done on this slide is I've actually set out all of the available lawful bases, and you can see that they differ quite significantly between whether what you're handling is personal data or the more sensitive type of data, the special category data, which is things like health data and trade union membership. And it almost in a way seems odd that there are more lawful bases available for handling the more sensitive data, so the orange boxes or special category data, than there are for normal personal data in green. But actually, the lawful bases available in the orange boxes are really quite limited. There's no option to handle this kind of data because you can say it's in your legitimate interest. The consent that you collect has to be explicit. So although it looks like you've actually got more flexibility, I would say you've got less, and the options are much more restricted. And really, that's exactly what you'd expect, given that it's more sensitive data.
I'm just curious that under the special category data, the legitimate activities of a non-profit, it seems like a non-profit seems to have more access. Is that right?
Yes.
Oh.
Yeah, so I would say that's correct. As an example, we act for a charity supporting victims of domestic violence. And in some of the support that they provide to those individuals means they have to collect like very sensitive data about what's happened to the individual and what they'd like to happen in the future, including things like police reports and how their children are being protected. Those kind of lawful bases there, as well as things like public interest and public health and vital interests, are there to support those activities of nonprofits. The other thing that I should mention, because you've asked the question now, so you've kind of opened Pandora's box on special category data, is that if you are handling personal data, special category data as a nonprofit, and you're relying on one of these kind of orange boxes, it's very much worth checking on the ICO's website whether you need what's called an appropriate policy document if you're handling of that data. That's a relatively new requirement that came in along with the GDPR. It's been in place for a few years, but it's one of those like quite esoteric requirements that a lot of the people that we talk to haven't really come across that often.
Sorry, what is the phrase again? Appropriate what?
It's an appropriate policy document.
Appropriate policy, okay.
Yeah, and on the ICO's website, they have a really useful like checklist of like when you might need one, and they also have a template on the website as well. Again, I'm happy to kind of stay on towards the end to go into that in a bit more detail. So what I'm going to do now to kind of close off like part one, which has all been about the key concepts, is we'll look at how do you have to handle personal data breaches differently if you're a controller or a process, and then we'll look at analytics. So when it comes to personal data breaches, if a breach happens and the data that was breached, you're a data processor either, then you would generally need to notify your controllers without undue delay. So you would be telling your customers, essentially. It's also very much worth checking that you're not under specific timeframe requirements in your contracts with the controllers. Because although the legislation says you need to notify them without undue delay, it's quite possible that your contract with your controllers says you'll tell them like within 24 hours, for example. And so the last thing I would want you to do would be to be in breach of contract because you waited too long. The other thing is it's worth checking if your contracts also require you to give them additional information. So it might not just be tell them the breach has happened, it might be tell them what data is affected, how did it happen, you'll keep them up to date every week or every day, for example. So it's worth bearing in mind here that when we're talking about breaches, there's like overlapping considerations between like what does legislation require us to do, but also what do our contracts with our controllers require us to do. Compare that to when we're a data controller. So as an employer, for example, we would need to notify supervisory authorities without undue delay unless we can show that there's like very little risk associated. I'm simplifying this slightly because I'm conscious of time, but what I will say is if you do suffer a breach and you're not sure, like, is the breach risky enough to warrant notifying the regulator? Again, it's going to sound like I'm on commission here from the ICO, but there is a really good triaging tool on the ICO's website that you can go through where they ask you kind of 5 or 6 questions about the breach, and it will help you decide whether or not you need to report that breach to the ICO. The other thing I should say, which applies to both controllers and processors, is that if you do have a breach, that should be captured on your internal register, like irrespective of whether or not the breach is serious to be telling the regulator or the individuals about it, you should be keeping an internal record of like what breaches have happened, as well as kind of the steps that you're taking to put them right in the future. And then the final point on the slide flags up that if there's a breach that's actually looking really quite serious, then we could potentially have to tell the data subjects as well. And when you first kind of discover this requirement, it can feel a bit counterintuitive, because what this essentially says is you don't always have to tell the people whose data it was that there's been a breach. And the guidance on this helps explain the thinking here. So the thinking is, if we told somebody, like if I received an email every single time my data was breached, then if there was a really serious breach that I needed to act on really quickly, it's likely that I just wouldn't care, because I get these emails, once or twice a week. So the thinking is, let's only tell the data subjects about the kind of more serious breaches, because we want to make sure that when we do notify them, they're taking appropriate action to limit the impact of the breach on them. And so just to wrap up the key concepts section, we'll go on to analytics. I should also mention that the slides here, I'm conscious, are really detailed, and I've done that because I'm keen to give you a set of notes to take away.
Yeah, thank you very much. Thank you.
No, it's fine. I should have said that at the start. I don't usually like having particularly detailed slides. So when we talk about creating analytics to commercialize the data we have, this again is something that I would approach slightly differently depending on whether I'm a processor, I'm acting for a processor or a controller. If you are a data processor, and it's worth making sure that actually, do your contracts with your customers allow you to create analytics? I would say in the majority of cases, when you're signing the customer's paperwork, they won't allow you to do that. But hopefully when you're using your own paperwork as a processor, you will be allowed to do that. It's also worth making sure that the data analytics you create aren't caught by a wide confidentiality clause in favor of your customer. So it's quite possible that if you're working to a really customer friendly agreement, then the confidentiality clause there will capture any kind of derived data, and that will be confidential information that you can't share or sell or commercialize. It's also worth, and this point's really important, thinking about, actually, is your analytics generation an anonymized process robust? If what you think is creating anonymized data is actually still identifiable data and still personal data, that risks putting you in breach of contract with your customers, and it puts regulatory risk on your business, because you're then a controller over that data because it's personal data. So this pulls us back to the original point, which is, if something's anonymized, it's not subject to legislation. And this, I think, dovetails really neatly here, because it's worth being very, very careful to make sure that actually the analytics you want to generate are genuinely anonymized. It's also worth covering off, again, this is mainly a contractual point, that the IP and the analytics vest in you. Let's compare that to, oh, sorry, I had a question, I think.
Just one example. Our first case study, our first project was creating a digital supply chain, in particular looking after the home worker. So sometimes the home worker could be very sensitive lot. For example, they could be discriminated because of their religion, whether they're Hindu or Muslim. And then the other one is like, sometimes they are kind of disadvantaged women, so they are kind of being a harassed group. Sometimes they also have harassment cases. But the information that we are processing, I would imagine, the goal is to find out who is below minimum wage, for example. So do you think that, what sort of precaution do you think? I mean, will we be in danger of being sensitive, to this data?
Yeah, for sure. So it's a really good question. And I would say this is exactly the reason why data protection impact assessments exist.
So we do have to fill in all these, yeah.
I would say yes, but for that kind of thing where your processing poses a risk to the individuals, you should be thinking about, if not completing, a data protection impact assessment. As an example, so the French equivalent of the UK regulator is called the CNIL. And they have guidance on their website around data protection impact assessments. And in one of those documents, they talk about a data project that involves the collection of location data from people. And one of the risks they identify is that, well, if we're collecting location data from people like regularly, and all of a sudden we know that somebody who's usually in one location that's their home is all of a sudden somewhere else, like we can make probably quite a good assumption that they're on holiday, or if they're hundreds of miles away, they're not coming back the same day. If that data is breached, there's a risk that somebody else, like a bad actor, could also gain that data, make that inference, and go and rob them because they know the house is empty. So those kind of things that you're talking about, particularly when the data is at risk of doing something like unfairly biasing people with disabilities, low incomes, impacting on the rights and freedoms of people. That, in my mind, if any of that is a possibility, that, in my mind, should be flagged as a high risk, and it's the kind of thing that needs further thought. It's not necessarily something where you have to go, we can't do that. The key thing to be able to show when you're thinking about these kind of data processing activities is that you've thought about the risks and you've worked through not only how can you reduce the risk of them materializing, but how can you lessen the impact of those risks on the affected individuals if they do materialize. Right. Often that results in things like collecting slightly less data, aggregating it at a higher level.
Okay.
So moving on to the creating analytics to commercialize if you're a controller, it's worth checking and making sure that, like, to the extent your analytics involve the aggregation of personal data, so where you would like hoover up personal data and aggregate it, you've got to tell people you're doing that. This comes back to the same point earlier around, like, the point of these kind of privacy policies is to be really clear with people about how you're using the data. You will also need to identify a lawful basis to create the analytics. Usually this is legitimate interests, which, as we know, carries a requirement for legitimate interest assessment. So that is the end of part one, which was all about kind of the key concepts and some of the top things that I think tech-based charities should need to know. In part two, we're going to cover using cookies and tracking tech on your website and apps and marketing. I'm also very conscious that we have 15 minutes left. I'm only halfway through the slides. So what I'm going to do is speed up a little bit as we go through it, and I will leave, you're welcome to a copy of all of these slides, because there's a few examples as we go through that you can look at afterwards if anything's particularly relevant for you. So in terms of what you should know these days is that the cookies rules and the guidance in particular has been updated relatively recently, such that websites have to clearly explain the cookies they use, clearly explain what those cookies do, and give individuals the ability to choose whether each cookie is accepted or not. Non-essential cookies, so things like tracking and analytics, should be set only if the user consents, and not as soon as the user reaches the website. I mentioned non-essential cookies because if you need to use cookies on your website or app to make your website work, examples would be make an online shopping basket work, for example. Those are essential, and these kind of additional consent rules don't apply to those types of cookies. On the next slide, I've included an example of how the ICO has interpreted their own guidance. So this is the ICO's cookies banner. Many of you listening to this may quite reasonably say, there is no way I'm putting something like that on my website when people first visit me, because it would have quite a negative impact on the user experience. Completely understand that. Alternatives, which I would not recommend, include things like including a bewildering array of buttons, which make it very difficult for the user to actually understand what they're agreeing to. If any of you are interested, this is taken from a website that's designed to test your ability to say yes or no to cookies. It's quite good fun. The idea is to get through this as quickly as possible, and you're timed. But one of our associates in our privacy team did this in about 40 seconds. I'd be interested to see. I can't do it anywhere near 40 seconds. That website is well worth checking out if you've got a few minutes. The reason why I flagged the rules on cookies, though, is because there are more legal cases now, particularly coming out across Europe, relating to non-compliance with cookies. We kind of ran through the baseline requirements earlier, and I would say, like, this is quite a difficult balancing act for controllers, because if you follow the legislation to the letter, you end up with something very similar to what the ICO has on their website in terms of a compliant implementation. And that causes a tension with marketing teams, because marketing teams don't want that to be generally the first impression of somebody on your website. So when it comes to the cookies rules, it's a bit of a dark art, really, like balancing like legal compliance and risk of being non-compliant against like, well, what's the commercial risk to us if our website starts putting off our users? Yeah, so it's like quite a tricky thing to work through. But again, like if anybody wants to chat about it in more detail, I'm happy to hang on the line or drop me an email at the end. So the second topic I wanted to cover in part 2 was all about marketing. And there is a draft new marketing code of practice coming through from the ICA. And essentially, when we talk about direct marketing, the definition here is really broad. It includes, crucially for charities, the promotion of aims and ideals, as well as advertising goods and services. So it's not necessarily just about trying to sell somebody something. It's also about trying to seek additional support or trying to promote kind of the core mission of your charity. And crucially, as well, it's any method of communication which is directed to people. The reason why I've included this is because like this includes social media direct messaging. That's one of my takeaways from the new draft guidance, that actually the ICO is switched on now. Like it's no longer just about email and phone marketing. These rules are also wider and go into social media messaging. I'm going to probably skip through most of this slide to keep us to time. But it's worth mentioning that the last point in particular, which is that the rules may apply differently for business to business marketing. And of particular relevance to charities and social ventures, the promotion of aims and ideals. So on the next slide, I'm hopefully going to answer like a key question, which is like, do we always need consent to send marketing material to people? No, is the answer to that question. But unfortunately, you very rarely get a positive answer like that from a lawyer without quite a large but, and this is coming. So you don't need consent, but it does vary depending on jurisdiction, particularly across the EU, as well as what marketing material are you sending and who are you sending it to. In the UK and most of the EU, you can contact a subset of business professionals. The definition here is complex. The wording, if you wanted to Google it, would be corporate subscriber. That's the formal legal definition that these people need to fall into, by email for marketing purposes without having first collected their consent. But it's really important that you work out, what are the rules in your jurisdiction and what are the rules for those specific individuals you want to contact about that specific thing. The other key point here is if you find out that you can contact somebody without having to get their consent, you still have to have a lawful basis for doing that under the GDPR. That will almost always be legitimate interests. The marketing that isn't based on an opt-in, which, as we know, means you need to complete a legitimate interest assessment and be sure that your use of data in this way doesn't unduly impact their privacy rights. What you should find from like a rigorous legitimate interest assessment process is that you think, actually, we can't just contact anyone who's a business professional for marketing purposes. You have to limit that to like a subset of people that you reasonably think are going to be interested in what you've got to say to them. And that won't object, and for example, who haven't opted out before. So what we'll do now is I'll go into marketing consent in a bit more detail, how to collect consent, how to collect your records, and then we'll do a little bit more on alternatives to consent around legitimate interest. Okay. If you are trying to collect consent for marketing, the individual giving consent must know the identity of the organization they're giving consent to. This sounds really, really simple, but it's still very common to see opt-ins that say, can we or our partners or our third parties? That's not okay. The individual organizations have to be identified. And if you're trying to collect consent on behalf of more than one organization for marketing, I would very, very strongly encourage you to use separate boxes. Consent has to be granular and specific. So I would be very, very wary of like trying to lump in multiple people in any kind of opt-in box. So explain to them, why do you want the data? What are you going to use it for? Tell them they can withdraw their consent at any time, and ideally also at the point of collection, tell them how they can withdraw their consent. So not just that they can, but how they can do that. Keep your consent requests separate from your general terms and conditions. There is no way you could include a marketing opt-in in your terms and conditions, and that would come anywhere near hitting the standard we need to hit under the GDPR. Linked to the privacy policy point earlier as well, use clear, straightforward language here. Avoid confusing terminology, such as double negatives. The other thing I'd encourage you to look at if you're somebody that writes these opt-ins or privacy policies is to look at dark patterns. There's some really good examples of how not to design systems to like influence people to like click one way or the other. And that kind of design where you're trying to push people to make a decision is called a dark pattern. Keep your requests concise and specific. What I've done on these slides as well is I've included a ton of examples from the ICO's website, but I'm going to skip through a little bit more quickly. So,
James, can I just interrupt for a second? So here we are moving away from personal data and into privacy, but privacy in the sense that because you know that person, and then you are invading into that privacy space. But knowing that person, in this case, it could be just an app on the iPad or something. Is that right? I mean,
yeah, but when we talk about this as well, if we collect somebody's email address, that will be personal data,
yeah,
almost certainly. So you're right that like the kind of narrative here is now like kind of more focused on privacy, but there's an overlap for sure, because when you send direct marketing to an email address, you not only have to comply with the marketing rules, you also have to comply with the GDPR because you're also processing personal data. So the two kind of dovetail together.
So the ICO now cover marketing as well.
Absolutely.
Oh,
yeah.
right. Okay.
Absolutely. Yeah. The ICO, I mean, we'll come up, the penultimate slide, I think, basically says that the ICO is far more actively regulating direct marketing breaches than they are general compliance with the GDPR.
Okay.
So this slide includes some notes for you on like how consent can be collected, just like the different ways you can do that. I've then included for you some examples of opt-ins. Both of these are taken from the ICO's website. When it comes to actually keeping your consent records, there's also quite a detailed list of things we should be holding so we can prove that we have consent. Again, this list is taken from the regulator. And the other thing that I'd mention here is most of the time, if you're using a platform, like examples would be like MailChimp, HubSpot, SendMail, I think is one as well, then a lot of the time they will help you in being able to maintain your consent records. But it's worth checking when you choose a platform provider, do they actually have functionality that matches the regulatory requirement that I need to meet in the UK? Because sometimes they don't. So it's worth bearing in mind that actually when we talk about recording consent and being able to prove it, this is what we need. Being able to say all of this, including retaining previous versions of your opt-ins.
Okay.
This is more examples, again, from the ICO's website around what would a good series of consent records look like compared to an inadequate set. So what are the key takeaways from this? When you have a compliant marketing consent means you've complied with all of the requirements we've discussed. If you have used an opt-in but haven't kept the correct records, then you probably do have consent, but you should work on improving the quality of your records because and a lot of our clients find ourselves in that position that there's often a gap between, oh, well, we've used an opt-in on our website that's really clear, but we can't necessarily tell you when that individual opted in, or we can't necessarily guarantee that like we have a copy of the exact version of the opt-in those individuals used. Also, you don't always need consent to send marketing emails to business professionals using electronic channels. But please keep in mind there is a real patchwork of rules across the UK and EU. It's important to know the rules in your key territories. The other thing I'll mention is that the promotion of charitable aims and ideals is generally one of the ones that you fairly often do need consent for. So be really careful if you're a tech-based charity trying to promote aims and ideals rather than necessarily goods and services.
What is the penalty?
Well, I've got some examples coming up of penalties. So there's also some recommendations here on using, making sure you have an unsubscribe link in your marketing emails. That's really, really important, as well as a suggested retention time frame. And again, I'm sorry for speeding up. I just want to keep the time. So on to some examples. So the first two sections set out that for breaches of security, Marriott, the hotel group, were fined 18.4 million, but that relates to 339 million records being compromised. There's also an online pharmacy that left medical records in cabinets outside in the rain that were unlocked. A contractor turned up to their site and raised concerns with the ICO about that. The ICO agreed it was inadequate and they were fined 275,000. Fines for breach of the marketing rules are common too. So Flybe, these are relatively old examples now, but I think they're still quite useful, were fined 70,000 for marketing to unsubscribed individuals. And Honda were fined 13,000 because, well, they argued that they didn't know whether they had a right to send the marketing in the first place. Because I wasn't able to quite cover everything in an hour as well in the slides, because there's just a ton of content in this area. I've included some more links on this slide to like give you a guide on the rights individuals have, more on the management marketing rules, what contracts should contain, and a guide on the record, on the data records you should hold. I'm conscious that was a really quick count to three, but that is the end of everything we wanted to cover there.
Yeah, thank you very much.
Thanks so much for your attention.
So detailed. All we need to know. Yeah, thank you.
Yeah, and please do reach out if you have any questions. My email's at the bottom, and I'll send over the slides for circulation so you can click on the links as well.
Yeah. So well, apart from thanking you, we have 1 minute to go. I keep having this question in my mind, going back to the Indian home worker. So the design is to have a platform, and then but the home workers are illiterate, you know, I mean, a lot of them, and then they don't really know how the digital network thing works. So the one of the features of the design is to have this kind of collective, in quote. So this collective could be a self-help group locally, or this collective could be an NGO towards the end. So this collective, let's say if it's NGO, then the NGO, implicitly is going to process all the personal information for the home worker, because this home worker is not able to do it. So presumably, I kind of trying to see which kind of regulation is going to fall in here. Presumably that will be a data controller, is it, or something?
Yeah, so I would have thought the NGO would be a data controller. And with those kind of risks where you have data subjects who potentially aren't able to read particularly well or would struggle to understand content, that's where the legislation challenges the controller. And the legislation essentially says it's on you to make sure you properly train people. And if they would struggle to read something, then communicate it to them in a different way that they would understand, and like be a bit more creative around how you do that. You should also be sensitive to like home working. So any content of the training that you do provide should probably be tailored slightly differently to reflect that people are working from home. So as an example, the training that we've given on working from home includes using things like privacy screens, making sure that if you're having a sensitive conversation, like, are you somewhere where you can't be overheard? Now, I know that comes from an incredible place of privilege.
I'm actually
not everyone has that.
I know that Chris is coming online now, but I actually have a much deeper worry in a sense that we are the designer of the platform. And then we have these NGO at the end who look after the home workers. So
yeah,
does it mean that this platform, we are the more serious responsibility or something? Because we had to make sure.
So if you're just the designer of the platform, but the NGO is like the main user with the people working from home in India, if that's true, then it's more likely that you would be the data processor as the one that's come up with the platform, and the NGO would be the controller. But if the platform is more a collaboration between you and the NGO, then you might even be joint controllers. So I would probably go back to that indicative list that we ran through earlier and like think like how many of those apply to us, because that will help you unpick like who's the controller and who's the processor in those different circumstances.
Yeah, that's a good point. Thank you very much. Thank you. Thank you.
It's a pleasure. Thank you, and thanks for your attention, everyone.
Yeah, thank you. So